All right, good afternoon, everyone. Thank you for joining me here today for this webinar, Unpacking the FTC's Final HSR Rule, What You Need to Know. My name is Mark Butscha. I am a partner here at Thompson Hine in our Cleveland office, and I practice in our business litigation group and antitrust subgroup and do a lot of work on HSR, which, as many of you probably have at least heard, is about to change pretty drastically in the coming year. And the purpose of the webinar today is to talk a little bit about that new rule and what some of the new requirements are, and hopefully give you some idea of what companies that are facing mergers going forward are going to be looking at when they have to file for HSR. So here's an overview of what we're going to talk about. First, I'm going to take a little bit of a step back, talk briefly about the HSR process, just to give a quick primer on that, to the extent you don't have familiarity with it already, because I think it becomes important in discussing what these changes are to the rule and understanding how they are going to work in practice. And then I'll talk a lot about the new HSR rule and what the new requirements are and how it came about. And we'll dive into some detail about those before talking about some practical implications and best practices when it comes to the new HSR rule. And then finally, I have questions on this slide, but please feel free to ask questions through the chat function as we go along, and I'll try to answer as many of those as I can. And hopefully get through what is a lot of information in a way that is a little bit digestible for all of you. So without further ado, I'll just dive into it. So first, I want to talk a little bit about what the HSR process is. So the pre-merger notification process under the Hart-Scott-Rodino Act means that parties to transactions must make a filing with the government, specifically with the Federal Trade Commission and Department of Justice, that identifies certain information for them and then requires the parties to refrain from closing the transaction until the HSR waiting period has expired. The waiting period is 30 days from the time that the HSR filing is made. Once that waiting period has expired, the parties are free to close the transaction from the perspective of the antitrust agencies. And although it doesn't preclude the agencies from later challenging a transaction as anti-competitive, in practice, that is extremely rare. And once you get through the waiting period without any investigation or lawsuit, you're free to close the transaction and are likely done with the agencies with respect to that deal. So when do you have to file HSR? HSR applies to acquisitions, mergers, and the like. Could be acquisitions of assets, voting securities, or what in HSR parlance is called non-corporate interests, which are really just interests in non-corporate entities such as LLCs or limited partnerships. And you have to file when certain jurisdictional thresholds are satisfied. Currently, any transaction that is valued at $119.5 million or more generally has to be notified to the agencies. There are a lot of exemptions I'm not going to get into today for these purposes. I just wanted to highlight that that's the sort of size of transaction test. The test goes up every year. Well, it went down one time during COVID, but otherwise it goes up generally every year according to the increase in the gross national product. Who has to file HSR? The HSR is filed by the buyer and the seller, so both sides have to file, and it is filed by the ultimate parent entity of both the acquiring person and the acquired person, meaning the buyer and seller or buyer and target. It's sort of an HSR term of art, but you basically go up the chain of control to the highest level entity, and that entity is the one that must make the filing. This slide just lists what is required to be filed with the HSR form. These are different items from the current HSR form that are required. An affidavit and certification certifying that the rules have been complied with, an affidavit testifying or attesting to the fact that the parties intend to complete the transaction, A brief transaction description is required by the form. That kind of just is the mechanics of what is being bought and sold and for how much. And along with that has to be included an agreement, or you can file currently on a letter of intent, and I'll talk more about that later because that's no longer going to be the case here in a couple of months. Transaction-related documents, you may have heard the term 4C documents. I'm going to talk a lot more about those here in a short while. Revenue data, lists of subsidiaries and minority investors and investments. And then if there's an overlap, meaning if the buyer and seller are both selling the same product or service or competing products or services, additional information has to be submitted as well. So what happens once you make an HSR filing? There's three outcomes, kind of like the big trend in baseball is three outcomes: walk, strikeout, home run. Three outcomes here with HSR. One is that the waiting period expires and then the deal may close. You may hear nothing from the agencies. There is no formal approval from the agencies if the waiting period is going to expire. You are simply notified when the filing is made that it's complete and when the waiting period expires. And if you hear nothing from the government in the meantime, you can close the transaction. Second option is that the government opens an investigation. There could be a preliminary investigation in which the agency staff reaches out to counsel for certain documents during the waiting period to try to further assess whether they want to initiate a full-blown investigation, which is known as a second request investigation. And the parties may decide, with the urging of the agencies, to pull and refile their HSR notification, which restarts the waiting period at zero. So if you pull and refile within that 30-day window, you effectively get a 60-day window in which to try to convince the agencies there's not an issue with the transaction from a competitive perspective. Or before the waiting period expires, the agencies could issue a second request, which is a big, basically a giant document, subpoena and interrogatories that is very burdensome, very expensive, and very timely to respond to, and often takes months and months to resolve and to comply with. And the third option is that a DOJ or FTC could file suit to enjoin the transaction, which ordinarily doesn't happen until after a second request investigation. So there's a quick primer on HSR. So there's a new rule coming out, and now what does that mean? So first of all, the rule goes into effect in February. It is entirely possible that once the Trump administration comes into power in January, there may be an administrative freeze placed on all executive rules that have not yet gone into effect. It's a pretty common thing that happens in new administrations. So it could be that February 10th date is pushed back a little bit, but I wouldn't expect it to be any more than 60 days from February at most, if at all. So the new rule was approved unanimously by the Federal Trade Commission, including 2 Republican commissioners who joined with the 3 Democrats to unanimously approve the new HSR rule. That probably signifies that there's not going to be successful litigation about this, although you can't rule out that someone is going to file suit in an attempt to enjoin the rule. But it has been approved unanimously by the FTC, 5-0, and there are statements by the Republican commissioners stating their view that the rule complies with the Hart-Scott-Rodino Act. The Trump administration could not unilaterally withdraw the rule at this point because the rule has gone through the formal rulemaking process under the Administrative Procedures Act and would require similar action in order to unwind it. So it could not be just sort of chopped on day one, even if the administration wanted to, which is not clear that it would want to do that anyway. The increased time and burden is significant with the filing. By the FTC's own estimates, it's going to take at least twice as long to prepare a filing under the new rule, perhaps 3 times longer or even more. There are estimates that would make it 4 or 5. Think it'll be 4 or 5 times more burdensome. That remains to be seen, I suppose. But the FTC, by its own estimates, is saying that the new rule will require at least double and perhaps triple the amount of time. And that is especially true in deals that involve product overlaps or supply relationships with respect to the same kind of products. Those require more information than filings for deals that do not include product overlaps, and I'll talk more about that in a little while. So what's new in the new rule? Well, two things it does not do. First is that it does not affect whether a transaction is reportable in the first place. Those rules remain unchanged. The jurisdictional threshold I talked about and the other rules about reportability remain unchanged. The waiting period remains unchanged. It's 30 days waiting period from the time of filing. Although there is one caveat there that the new rule does say early termination will return. It has been temporarily suspended since 2020 during the pandemic. But early termination means that the FTC has discretion to terminate the waiting period earlier than the 30 days for transactions when the parties request it. And the transaction obviously or clearly to FTC does not have any competitive concern. If there's no product overlaps, for example, that could, or if it's just an investment made in stock, but there's no sort of competition between the buyer and the seller, the agencies might grant early termination. The information that's currently required to be submitted with the form I went over a little while ago, kind of briefly, virtually all of that information is still going to be required under the new rules. The big difference with the new rules is that there will be more information required, perhaps significantly more depending on the transaction. Narrative submissions and additional documents, additional data, and additional disclosures. And I'm going to go over each one of these in more detail. But the real upshot from the new rule is that more information is going to be required. So the first thing that is a bit different that I'm going to talk about is a definitive agreement. I mentioned before that currently, under current rules, you may file HSR on a definitive purchase agreement, such as a merger agreement or a stock purchase agreement or an asset purchase agreement. But you also may file on a letter of intent. So even if a definitive agreement is still being negotiated, the parties can agree that they're going to file HSR on a letter of intent. The FTC has expressed concern that filing on letters of intent often does not give them the information that they need to assess the competitive effect of a transaction. And so they have done away with the ability to file on a bare LOI unless the LOI or a term sheet or a draft agreement has material terms already set forth in it, identifying the parties, the transaction structure and the scope, the purchase price, closing timeline, employee retention. Without those sorts of material terms in a draft agreement or a term sheet or an LOI, however it is styled, you may not file HSR. Other agreements must also be identified in the filing, including non-compete agreements, supply agreements, licensing agreements, and leases. I mentioned narrative submissions a little bit earlier. So currently, under the HSR form, the parties must include a description of the transaction that's very brief in item 3 of the form. Basically, the parties have to say who they are. Company A is purchasing all the voting securities of Company B pursuant to this agreement. The business operations of the target need to be described, but usually it's pretty brief. I mean, it might say, Target engages in the sale of widgets in the United States, something very brief like that. The new rule is requiring much more information in the form of a narrative response. The business operations have to be described in more detail than they have been right now under the current rule. The strategic rationale for the deal has to be set forth. So that's something that is not required under the current rule. The categories of products and services, including whether the parties compete with each other and how they compete with each other, has to be set forth in narrative form. If the parties have a supply relationship with each other or a licensing relationship, that has to be disclosed and explained. And all of those explanations in these narrative submissions must be supported by citations to documents that are also submitted with the form, whether that, that could be ordinary course business documents that evidence the relationship between the parties, that evidence the products and services that they offer and their competition or lack thereof with each other. But in any event, they need to be supported. The submissions need to be supported by documentation or citations to documentation. More data. So I mentioned more data, more documents, more information. We'll talk about data first. So currently, under the HSR form, parties need to supply the agencies with information, sales information, revenue data, broken down by NAICS code, the North American Industrial Classification System code. It certainly is a heavy lift for some parties and not as much for others, depending on how your data is kept. But now additional data is going to have to be required. For deals that involve horizontal product or service overlaps, in other words, when the target and the buyer sell competing products or services, those products have to be identified and data has to be provided for each product that is competing, product or service that's competing with each other. A list of the top 10 customers must be provided for those products and services. And it even includes or requires additional information related to products that are in development or that are being developed that could be in competition with the other party, including potential revenue that may be generated by those products. So none of this is currently required under the HSR rules. And this would certainly be a more onerous undertaking at the outset when a party is thinking of filing HSR. This data is often requested by the DOJ or FTC during the initial HSR waiting period when they're sort of poking around to see whether there might be a competitive concern for them. So it's often information that parties need to collect and put together and produce to the government during the waiting period. But now all of this information is going to have to be submitted at the time that the HSR form is filed. So not only is more information required for deals involving horizontal overlaps where parties are selling competing products, but also needs to be submitted when there are vertical supply or licensing relationships involved. When there are vertical supply or licensing relationships involved, the parties need to, or the parties, excuse me, need to produce revenue data. This is for the buyer. Revenue data for products and services that are sold to the target or any competitor of the target, and the buyer's top 10 customers for those products and services. And the other way up the supply chain is also true. Data for products and services that the buyer purchased from the target or any competitor of the target must be provided, including a list of the top 10 suppliers for that product or service. So this additional rule is coming out of the fact that the FTC and DOJ have been more focused on vertical relationships in the past few years, in addition to the traditional horizontal relationships that antitrust law was concerned with. And the supply and licensing data is meant to allow the agencies to assess that sort of relationship and whether there's any competition concern with respect to, foreclosing a competitor of the target from selling products or from purchasing a necessary input for their own products that they are making. So that was the more data section. There's a little more data later, but I think I'm calling it information. But now we're going to move on to the documents section. So more documents. For anyone that has prepared an HSR filing before and gone through this process, they know that the most onerous and important part of the filing is collecting and reviewing so-called Item 4C documents. Now, the new rule is less onerous than what was proposed by the FTC in the middle of last year, but is still very much expanded from what the rule requires currently. So what does the rule require currently? What's an Item 4C document? An Item 4C document is a document that must satisfy all of three criteria. One, the document is prepared by or for an officer or a director. 2, the document must be created for the purpose of evaluating or analyzing the transaction. And 3, the document must relate to competition issues or an analysis or evaluation of competition issues, such as market shares, competition, competitors, markets, potential for sales growth or expansion into new markets. Common examples of these sorts of documents that are often submitted with HSR filings include confidential information memoranda or presentations, board presentations, management presentations, board minutes, third-party analyst reports or market studies, and it could also include emails or notes and the like that relate or that satisfy all 3 of these criteria. Importantly, drafts of these documents do not need to be submitted under current rules. So if you create 10 drafts of a board presentation that analyzes the deal with respect to your competitors, those drafts do not need to be submitted under HSRs under the current HSR rule. Last year, the FTC proposed requiring requiring all drafts of responsive documents to be submitted. But I think thankfully, perhaps they realized that was going to be burdensome for them, or perhaps they realized it was going to be too burdensome for the parties, but they have scaled that back, although it is still expanded more than the current rule requires, which I'll talk about right now. The new Item 4C rule is expanded. It requires looking at additional document custodians. It requires more drafts than are currently required, which are basically none, but I'll talk about that in a minute. And it requires more documents that are unrelated to the transaction itself. Item 4C required, as one of the requirements, required documents to be actually evaluating the transaction at issue. There is an exception to that now in the new rule, where certain ordinary course business documents will need to be submitted. And in addition, English translations of documents will need to be provided under the new rule. So first, I mentioned people, more people. So currently, Item 4C documents only need to be collected from officers and directors. The new rule expands that obligation beyond officers and directors to include what is being called a supervisory deal team lead. This means the person who has primary responsibility for supervising the strategic assessment of the deal. So essentially, I know many companies have corporate development departments, and one person who is leading the deal team for that deal would be deemed the supervising deal team lead. And so any documents prepared for that person would now also be responsive and need to be submitted with the HSR form. In the past, this person was kind of a conduit between the deal team and officers and directors, and perhaps would have seen documents that the officers and directors never saw because the deal team lead didn't find it necessary to provide that information to the officers or directors. Now, it doesn't matter whether the supervisory deal team lead provided that information to the board or to the officers. That information or those documents must be submitted with the HSR filing, assuming all the other criteria are met, meaning the competition-related issues. So if an assessment of the deal with respect to the market involved or competitors involved is prepared by the deal team, and that assessment is shared with a supervisory deal team lead, that document will need to be provided regardless of whether it was actually provided to officers and the board. The current rule, as I noted, does not require the submission of drafts of otherwise responsive documents. Only the final version has to be supplied with the HSR form, unless the draft went to the entire board of directors. That is no longer going to be the rule that the FTC will enforce. Instead, now drafts will need to be submitted if they went to any board member. So rather than having to go to the entire board, a document that's responsive, and even if it's a draft, it goes to any member of the board, it is no longer considered a draft and must be submitted. And this is perhaps a bigger issue where you have an officer who is on the board, like the CEO, because then any document that the CEO sees could be deemed could any document in the files of the CEO or other officer who was a board member could be swept into this requirement. In the past, if a draft went to, or in the current rule, I guess, if a draft goes to the CEO, that draft does not need to be submitted if there's a later final version. Under the new rule, the drafts that go to the CEO would need to be submitted, assuming that the CEO is on the board. So in the context of private equity as well, principals or directors would be subject to the rule as well. And so this is a potentially large expansion of the universe of documents that may need to be collected and reviewed and submitted, depending on the relationship between the CEO and the sort of hands-on, whether the CEO is hands-on with the deal team and with evaluating transactions. And a lot of that will just depend on the size and structure of your company. So ordinary course documents. Under the current rule, only documents that are created or prepared for the purpose of evaluating the transaction must be submitted. In other words, documents that are created in the ordinary course of business, such as strategic business plans, regular reports to the board about the business, those sorts of documents do not need to be submitted under the current rule, but now will need to be submitted with some limitations. So the documents have to be existing documents, in other words, not created for the purpose of responding to this item, but existing documents discussing competition issues related to overlapping products or services must be submitted if they were created within a year of the filing, and if they were provided to the CEO or to board members. Excuse me. These types of documents are often requested by the agencies during the waiting period if they're opening a preliminary investigation to determine whether they want to open a larger investigation into the transaction. And now again, as was the case with some of the customer and sales information, these types of documents are being required at the time of the HSR filing rather than during that preliminary investigation period. The fact that there are going to have to be a lot more documents submitted with the HSR filing, including ordinary course business documents, highlights the need to engage in good document creation practices. Item 4C documents that what I would call problem item 4C documents are the biggest risk factor in determining a likelihood of an investigation and in questions from the agencies. So companies and individuals, employees should be careful when creating documents to be sure they're not touching on antitrust sensitive topics, using unhelpful language that's exaggerated and not accurate, because it will certainly garner the attention of the agencies. Now, those documents include sort of ordinary strategic planning documents and the like. And companies and employees need to be careful when creating those documents if they are going to be engaged in any kind of M&A activity that may result in HSR having to be filed. It's always a good idea to engage counsel to help review documents to help avoid some of these issues with inaccuracies or misinterpretations that could occur because of exaggerated language. And when in doubt, employees should assume that every single email and every document that they prepare and that they write is going to be read by the Federal Trade Commission or DOJ. Some other additional rules or additional information that's required under the new rules. Minority investors. So currently, parties need to submit an acquiring person, so a buyer, needs to submit a list of its subsidiaries, and it also needs to identify minority investors in the ultimate parent and in the acquiring entity. Minority investors holding 5% or more of an interest in either of those entities. So that requirement is now going to be expanded to include not only the ultimate parent and the acquiring entity, but also entities that are controlling or controlled by the acquiring entity. So the illustration on the right there, under the current rule, ABCD, or the UPE at the top, let's say that sub B is the acquiring entity. Under the current rule, only A, B, C, D, and B would be required to disclose minority investors that with 5% or more interests. Now, A, C, and D would all be included in the definition of covered entity and need to disclose minority investors. For limited partnerships and private equity funds, this is especially potentially burdensome. Limited partnerships must disclose limited partners that have board nomination and approval rights for any covered entity or general partner or the management company. That's significant expansion of the disclosures that are required under the current rules. Identification of officers and directors. In the current form, there is no requirement to identify any officers or directors of any entity, whether that's the UPE, the buyer, the seller, except to the extent that they authored certain documents that are disclosed as Item 4C documents. But now officers and directors will have to be identified in some fashion. The requirement is limited to entities that are responsible for development, marketing, or sale of product or services that are identified as overlaps or supply relationships. So again, like many of these requirements, the information is going to be less onerous for a transaction that does not involve competitors or competing products or services. If you do need to disclose, the disclosure requires all the names of all current officers and directors and those who served in those roles in the 3 months prior to filing. If they also serve as an officer or director of another entity that derives revenue in the same industry as the target. So what is driving this new requirement? Section 8 of the Clayton Act prohibits interlocking directorates, which means that the same individual cannot serve on the boards of competing companies. The FTC and Department of Justice have made this a point of emphasis over the past 3 or 4 years. They have launched a few investigations and reached a few settlements about the interlocking directorate issue. And in their view, interlocking directorates not only violate Section 8 of the Clayton Act on its own terms, but also raise the likelihood that competition would be substantially lessened, and therefore that a transaction could violate Section 7 of the Clayton Act if the transaction will result in a board interlock. Prior acquisitions. Under the current form, the buyer and only the buyer must disclose prior acquisitions if there is a horizontal product or service overlap. Prior acquisition requirement requires an identification of entities purchased or acquired in the last 5 years if those entities have $10 million or more in assets or sales. So currently, as I said, that only includes the buyer, but now that requirement is also expanded to include the target and any acquisitions that the target made in the past 5 years. Excuse me. The impetus behind this requirement is the concern in the past few years expressed by the FTC and DOJ with respect to nascent competition and companies and entities being purchased before they present a competitive threat to the buyer. And then if they are then purchased by an acquirer later, those acquisitions might not even show up in the HSR form under current rules. So they're trying to capture that information with this new rule. Other jurisdictions, foreign jurisdictions. As you may or may not be aware, there are hundreds of jurisdictions around the world at this point that require merger control filings if the economies in their countries are affected in some fashion. Under the current HSR rule, whether you disclose that you have made such a filing in another jurisdiction is voluntary, and now that will be mandatory. So if a filing is going to be made in the EU, or in South Africa or in China, that has to be disclosed along with your HSR filing to the U.S. government. Voluntary waivers, as you may or may not be aware, the HSR filings are confidential by statute, and they're exempt from FOIA. And so the DOJ and FTC cannot actually share information about the filing, even with other enforcement authorities in other countries or the state's attorneys general, excuse me. They often, if they're going to open an investigation, will ask the parties if they want to waive that confidentiality requirement. And depending on the circumstances of the transaction, parties may wish to do that. Now the parties have to tell the government up front when they file HSR whether they want to make that voluntary waiver. National security issues. The Filing Fee Modernization Act, which was passed 2 years ago, required the FTC to come up with a rule regarding the disclosure of foreign subsidies along with their HSR filings, and this reflects that directive from Congress. So what needs to be disclosed? Any subsidies from governments of concern, China, Iran, North Korea, Russia, have to be disclosed. And the party must identify and list products that are purchased from those countries that are subject to countervailing duties or investigation for such countervailing duties in any jurisdiction. So this is really a sort of international trade type of requirement that has never been required on an HSR form before. Many other countries do require this type of information along with their merger control filings, and this sort of brings the U.S. into alignment with that on some level. But it's a new requirement to be aware of. Relatedly, defense and intelligence contracts involving overlap products, meaning products that the buyer sells in competition with the seller. Contracts related to those products that are valued at over $100 million have to be disclosed along with the HSR filing as well. I mentioned at the outset that the timing or that the burden of preparing a new HSR form is significant compared to what the HSR rule currently requires. There's more information to collect and prepare, which inevitably means longer timelines for filing. As a practical matter, currently, for most merger agreements or purchase agreements, the parties would probably agree to file within 10 business days or so of when the formal purchase agreement is executed. Sometimes that's shorter. Sometimes it could be 5 days or 3, or it could be longer in some circumstances. But 10 days is probably pretty optimistic, unless a lot of work is done up front before a formal agreement is executed. And I think that probably 10 days is probably too optimistic. I would think 15 business days to 25 business days is probably more likely the timeline for putting together all this information and preparing it for filing. Certainly companies who are doing it for the first time under the new rule is probably should build in a little more time for that, because you're going to have to be doing a lot of this for the first time, and there may be efficiencies gained by even doing some of that up front if you are thinking about acquisitions or divestitures in the coming year, thinking about what types of information you can put together now and have it at the ready to be able to file more quickly. But in any event, I would expect longer timelines for filing to become more of the norm in your covenants and your purchase agreements. So training on document creation. I mentioned document creation before as becoming even more important, given that the requirements for what kind of documents need to be submitted are going to be even greater. The narratives that have to be submitted with respect to the products and services offered and the competition between the parties have to be based on and cite to company documents. So in many ways, this could actually be an opportunity to push forward some of the strategic rationale for the deal that is pro-competitive, and to put that information before the agency in a way that is most beneficial for your companies and for your clients. And focusing on those benefits up front will allow you to do some advocacy in the HSR filings that maybe is not actually really, not that it's impermissible now, there's just not really much room in the HSR form as it currently is constituted for much advocacy. And so this provides some opportunity in that level, even if it is a bit more onerous. So assessing the risk early on is important. Deciding whether you believe an investigation is likely or possible, whether the deal is likely to go through and be approved under a certain timeline. The earlier that's done, the better you'll be able to assess the risk when you're negotiating a merger or purchase agreement, including when to file and who should bear the risk of an investigation and the cost of that. It will also help develop strategy for advocacy, as I mentioned just a second ago, by using the HSR to explain transaction benefits. And it also allows you to identify potential problems early and be able to identify overlaps, develop narratives, and to put the best foot forward when you have to submit your HSR filing with all this additional information in it. So the parties on both sides of the deal should be aligned on process when it comes to these new requirements. It's in the interest of both parties, the buyer and the seller, to be on the same page with respect to preparing for the HSR filing and developing a narrative that will help highlight the pro-competitive benefits of the transaction at issue. Understanding any of these things up front, whether it's with product overlaps and horizontal overlaps and competition with the target or the target's competitors, or your relationships with your suppliers, or the relationships between your suppliers and the target, allowing counsel or with the advice of counsel, getting an understanding of those relationships will help help your planning process, help your risk assessment early in the process as you start preparing the HSR filing. It's probably important to include business people, especially if you have corporate development departments or deal teams that are going to be preparing documents related to transactions, to help get them on the same page with respect to why is this deal happening? Why is this deal good? And developing a good story to be able to tell to the agencies about why the deal is not problematic. And that folds into pretty much every single one of these new requirements. I'm glad that everything was so clear to everyone. I don't have anything else to talk about on this. I know that was a pretty quick run through of these new requirements. I hope you found it useful and at least trying to spot issues that may arise as you're contemplating transactions that might trigger HSR reportability, including thinking about document creation and the like. And I hope you found this useful, and I appreciate you coming. Thanks very much.